Good morning, everybody. I am back again, and I'm your host, the Supreme Litigant. I'd like to welcome everybody back to Smart Loke TV. A lot of people say lock, but it's really Loke. And if you're a Loke, then you know what I mean by that. Give y'all a hint. Nipsey Hussle. I'm gonna give y'all a hint. Nipsey Hussle was a Loke. That'll be it. I'm not gonna say anything else on that. R.I.P. to the law, to the legendary 6-0 Loke. Nipsey, by the way. Nipsey Hussle. Shout out to the neighborhood Lokes. Also. Anyway, let's get back to this, y'all. Hit that like button for me, y'all, if y'all don't mind. Before I get back into the ebook, I want to show y'all something. This right here, I was watching Yusuf's video, Yusuf L. This is part 2. He's mentioning a lot of good stuff in this video, but I think there's some stuff that he didn't mention that should be mentioned. And so what I'm going to do is after I finish doing this video, I'm going to make a video providing y'all commentary and case laws on what he's saying in this video. Shout out to Yusuf L, by the way. If you haven't already, please go ahead and subscribe to his channel. I don't agree with everything what Yusuf says, but majority of it I do agree with it because he's right. And that nigga know what the fuck he talking about. Y'all can say what the fuck you want, but he know what the fuck he talking about. Shout out to Yusuf L and High Frequency Radio, by the way. All right, let's get back to the ebook. Okay. I think we stopped. Did I think I'm gonna start. Excuse me. I'm gonna start about right here, and we'll go probably about. I think I do maybe about 7-8 pages. So we'll do another hour-long video. Attorneys are failing, if not outright refusing or assisting this injustice. Well, let me go back up to see which injustice it was. As you can see, for now, courts have precedents to offset and displace strict scrutiny. Strict scrutiny is a standard that the courts are required to apply in regards to fundamental rights. Just to let y'all know, courts have precedents to offset and displace strict scrutiny, protection of fundamental rights in mother-father custody contest proceedings, which allows the well-known bias best interest standard that the best interest standard is a standard less it's not as strong as the strict scrutiny standard to take its place. As such, there is no heightened protection. That's basically what the author is telling y'all. We now can pinpoint which then allows a court to grant every other weekend visitation or privilege is not a fundamental right, and they are also correct in that. Attorneys are failing, if not outright refusing or assisting this injustice. Parents and lawyers not only do not utilize property rights in the right to services and labor of children, property rights, but they also do not utilize other fundamental interests, such as the father's right to religious upbringing, that is a fundamental right, the right to education, rearing, and the right to rear one's own child how he sees fit without government intrusion. Those are all fundamental rights, just to let y'all know. Fundamental rights are not civil rights. I'm going to stop right there and tell y'all what civil rights are. Now, I have not found any case law on this. Okay. And the reason why I'm saying what I'm about to say is because civil law is statutes and codes. Okay. That's what civil law is. So it is my contention, and I believe that this is a reasonable conclusion that I have based on what I just told y'all, that civil rights are created via statutes, meaning they are given to you. Let me rephrase that. They are given to their subjects by the government, and you are not a fucking subject. On to the next. The attorneys, however, are refusing to do so in order to remain cordial cordial and friendly with the Bar Association, including the local judges, simply because their career will be on the line, if not more. Moreover, fathers lack the knowledge to do so or simply outright fear to do so because of retaliation by judges who hold the power to literally alter their child's future and is protected by enforcers of the law. However, failing to invoke these rights are akin to walking into a war without a weapon and expecting diplomacy. That's a good analysis. As we are now learning that diplomacy has long passed, we must take up the arms of intellect and knowledge and fight for our children with the only protections many men died to protect. We must utilize what they sacrifice for this very dark time, or their sacrifices are in vain. I wish to add to the right to religious upbringing statement made in the last paragraph. This is simply more ammo to add to your arguments about that, in my opinion, simply cannot be, arguments above that, in my opinion, simply cannot be defeated. One should be mindful of the arguments that I call the father still has a say-so litigation of encroaching opposition. In other words, one should be on the lookout for attorneys, judges, or justices that may and will state that one is not deprived of the right to religious upbringing or even the right to the child services because you, as the father, allegedly still has a say so, even if the mother is granted final decision making authority over custody. Now I'm gonna stop right there. Um, the reason why I'm about to say is what I'm about to say is because if a small infringement on your right is still an infringement. So you're not able to exercise I'm gonna say plenary power over these fundamental rights that you have with your with your kids, your offspring, if there is a so-called court order infringing on that right. If that makes sense, it makes perfect sense to me. It makes perfect sense to me. So a little infringement is still a violation of your rights, and you should me personally, I don't want motherfuckers in my business telling me what to do with my kid, and you're not helping me take care of this kid. You're not bathing this kid. You're not punishing this kid when the kid needs to be punished. You're not teaching this kid. You're not spending time with this kid, so on and so forth. Everything that a parent should do, with their kid. You're not doing none of that, so fuck you. You need to stay the fuck out of my business. Unless you have a lawful purpose for infringing in my private life or for treading on my private rights. Me personally, I really don't give a fuck what a statute says. I respect equity and the laws of nature. When you have facts that show that, that I'm a bad parent or so on and so forth like that, and it's proven, everybody knows it, whatever you want to call it, then yeah, I'll get some act right. Because I don't want you to take my motherfucking kid away and give him to somebody else. And I'm certain that that the kid doesn't want that. They want to be with their mother and their father. However, fathers shall know that just because it is written by an attorney or even a judge does not mean it is true, and it is 100% correct. It is up to you to prove it. It is up to you to prove it is not true without a doubt, even if that means you take your arguments to the Supreme Court. 100% correct. I'm going to stop right there. Let me tell y'all something else. I don't give a fuck what a judge says or an attorney says in a courtroom. The court rulings, like what the judge say or whatever, everything, all of that shit is a presumption. So if the judge is trying to assert an argument in support of why she or he is ruling the way that she or he is ruling in an opinion, and this argument is false, then you need to dispute it because it's a presumption. And since it's a presumption, it can be rebutted with proof. You need to do that every time that they do that shit because they will do it. They did it in one of my cases. Be mindful of the sovereign community who may get the green light to gaslight this chapter, as their arguments and the individuals allowed to make them, let me see, gaslight this chapter, as their arguments and the individuals allowed to make them on such a mass scale has caused the continuation of a lost people. Oh, I wonder what they're talking about when they say that. Case law here. The court does not take issue with the fact that under California law, respondent retains a right to influence his daughter's religious upbringing, okay, and to interpose and to expose her to his views. But it relies on Banning's view of the merits of this case to diminish respondent's interests. So there's no issue with and to expose her to his views. But it relies on Banning's view of the merits. What is Banning's? What are they? I have to see. Well, I probably need to read that case to see what they're talking about. On to the next. Based on my finding, I would rule in favor of a father who would make the argument that he is deprived of his right to his child's religious upbringing, and that their father's issue is not with the board deprivation of the fundamental right. What are they talking about? I'm gonna read that one more time. It's a little confusing for me. Based on my finding, I would rule in favor of a father who would make the argument that he is deprived of his right to his child's religious upbringing, and that their father's issue is not with the board deprivation of the fundamental right religious upbringing, but the act of this diminishing this right and interest solely by state action that transformed the parties' democratic joint legal custody relationship into autocracy. I'm gonna have to see what they're talking about. He might got the author may have a good argument with that. I have to see what they're talking about. Unless they're going to explain it right here. FY, joint legal custody relates to decision making only. Joint custody or visitation relates to overnights or time spent only. Okay. A court's first thought or order may state something along the lines as the parent given final decision-making authority is deemed to act in the best interest of the child as custodial parent. So such a decision was made, and the father still has a say-so, just not final say-so. I see what they're talking about now. However, this is the point of the argument. A father's rights have been diminished exactly. 100% right about that. By transforming the joint legal custody argument into autocracy. However, we must remember how this argument can even be made, or even why. This is why. We are attempting to displace the best interest standard with substantial protection. So what the author is saying is they are by making a fundamental argument. Let me rephrase that. By making a fundamental right argument in regards to your kid in maybe what is it, juvenile court case, whatever. As long as it's a court that adjudicates so-called court that adjudicates cases involving kids, so to speak. If you make that type of argument, the courts, the so-called courts, would then be under. They can't use the best interest standard. They are required to use the strict scrutiny standard, which is a harsher standard for them to overcome in order to do what they're trying to do with your kid. Basically, that's what the author is saying. Let's see. This is why we are attempting to displace the best interest standard with substantial protection by first alleging this fundamental interest, right to religious upbringing, including others. The how is we are proving that not only is this right a fundamental interest, but it can be deprived even when a court attempts to allege that final decision making authority rulings does not affect substantial interests or is even a substantial interest. Let me see. I'm gonna read that again. We are proving that not only is the right to a fundamental interest, but that it can be deprived even when a court attempts to allege that the final decision-making authority rulings does not affect substantial interest or is even substantial interest. Okay. However, again, this is only one argument out of several to be made, which we are only making to invoke constitutional protections for substantial protection in custody proceedings to protect equal custody arrangements. These are some good arguments, too, just to let y'all know. I fully agree. I see exactly what the author is trying to do. And they are on point with this. Yep. I'm gonna tell you what they're trying to do again. The reason why you want to bring up constitutionally protected right arguments is because when you do that, they cannot use the best interest standard. Like when they say in the best interest of the child, they can't use that standard. They can't use it anymore. They have to use strict scrutiny because they are encroaching on your private rights. I will now revert back to the initial arguments fathers have. That is, the property right to the services of labor of one's child and fathers. Read here. Unless parental power has been lost or relinquished, a parent is entitled to the value of services of the minor child. Did I just read? Well, yeah, I'm gonna read it again. Unless parental power has been lost or relinquished, a parent is entitled to the value of services of the minor child, whether contract for services is made by a parent or the minor child or the minor, and even payments made by an employer to a minor for necessaries. Okay. Now these are some old cases, y'all. They're very old. So if you go online, you may not find some of them online. That's why I'm telling y'all that. You're gonna have to go to a law library because there's a website that I use a lot. It's called Case Text, and you'll see it you'll see it in some of my videos a lot. I actually use a case text a lot in a lot of my videos. But some of the cases that I look for, they're not on case text. So you have to go down to maybe a local law library or go on another website, and it may be on that website. The right to the custody and the earnings of his minor children are reciprocal, and that whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. Who, 1929. Let's see. Parents deprived of custody, meaning given visitation without fault on his part. Okay. Parent deprived of services related to custody, which a man would now lack. Parents deprived of custody and services without fault on his part. There are no broken vows in marriages, so what else could be fault other than failure to provide maintenance, which most fathers I have spoken to and of wish to be given the chance to do so without force, coercion, or spiteful refusal. Yeah, I would agree with that. Parents deprived of parental power and thus parental has been lost without fault on his part. All of the above, thus depriving father of the obligation of support. Yeah, I'm gonna stop right. I just want to just say this. I do apologize, for the stuttering and the mispronunciation of words in this video. But when I start reading, when I'm tired, I start stuttering, and sometimes I start stuttering, and my head it starts hurting. So that's why. And I'm just like everybody else, I'm a little dyslexic myself, so But back to it. Uh, the case laws used above are to prove a broad point that applies nationwide. However, fathers must view these findings as an attorney or a state who makes a profit off of your child's pain seeking to attack your offense. I agree with that. So, in turn, you must organize your offense in preparation for their defense. You must organize your offense in preparation for their defenses. I agree with that. To ensure no defense can pierce your offense. I agree with all that. So, what are the defenses in a hypothetical situation? I myself have placed some below, but you should use your imagination and knowledge. Attorney parental power, as it relates to the educational and religious upbringing, is not lost because the parent has joint legal custody and still retains a right to the educational and religious upbringing. I would rule in favor of the argument that their issue is not with the board deprivation of the fundamental right, religious upbringing, but the act of diminishing their interest in such a right solely by state action that transformed the parties' so-called democratic joint legal custody relationship arrangement into an autocracy by giving one parent final decision-making authority without determining whether that should have took place under heightened scrutiny, or if under heightened scrutiny there was simply no substantial justification for it, because under heightened scrutiny the parent would be entitled to substantial protection. Give me 1 second, y'all. All right, let's see. Attorney may say parental power as it relates to the custody, meaning overnights, and not merely just decision making authority. It is not lost because the parent has a right to seek custody of the child if substantial circumstances change. Before he cannot be deprived of the right to services, thus relieved of the duty of support. Before I would attack this before let me see before I would attack this before ruling. I'm not even sure if I read that right. Before I would attack this before ruling, I would consider if visitation is the father's only form of physical time parenting with his child, and would determine if there is any absence of joint custody verbiage in his custody order. I would do this because I would simply state that visitation is not custody relating to overnights. This is extrajudicially proven by local police and district attorneys who refuse to prosecute mothers who violate visitation rights. Why? Another big kept secret is that those criminal statutes only protect custodial parents and custody interests, hence lawful custodians. Let's see. The purpose of OCGA Section 16545 is to protect the custody interests of the child's lawful custodian from interference by another person. So that must be like an affirmative defense or something like that. Is that the same? That's the same statute, but it's a different subsection. So OCGA Section 16545, Section A3, lawful custody means that custody inherent in the natural parents, author parental power. Okay, that custody awarded by proper authority has that that custody awarded by proper authority as provided in Code Section 1511-133, or that custody awarded to a parent, guardian, or other person by a court of competent jurisdiction. Now again, does the father have custody rights or visitation privileges? Here's that word again, parental power. Until majority, a child shall remain under the control of the father, but that parental power or control may be lost in any of six ways. Okay. There has been no loss of parental control by the father, but there has been an award of temporary custody to the mother pending divorce proceedings. We do not believe that under the laws of this state, an award of temporary custody to the mother pending divorce proceedings would be such a decree of a court as would serve as the basis for conviction of the father of kidnapping his own child from the mother. These folks are trip. A decree awarding temporary custody is a matter of discretion with the court. It is not an adjudication of the rights of the parties. That's interesting. The best interests of the child pending adjudication of the rights of the mother and father are the basis for the award. The parental rights of the parties are not adjudicated by the award of temporary custody. I see what the authors did. That author did some damn good research, y'all. I'm gonna see if I can get them on the show and let them provide some commentary and just answer a few questions about this, because this is some damn good information. What I am doing is technically horizontally proving my claims facing me vertically, so that I may exercise discernment in my decision in front of me. I now know that custody simply does not mean visitation based on the above, and further that if parental power is not lost in temporary custody proceedings, then it is surely lost in final custody orders. Moreover, view the case law below that answers this question. There can be no doubt but that the awarding of the custody of the child to the plaintiff in decree of divorce deprived the defendant of his rights to her services. He could not command her services while the plaintiff was entitled to her custody. However, be mindful of the father still has say-so litigation that I warned about. However, being granted visitation is not a form of lawful physical custody. Joint legal custody is only a right to make decisions and is separate and distinct from joint physical custody, right to equal placement. Therefore, parental power is lost, and the father is indeed deprived of the right to services and labor of his child, relieving him from the duty of support, so long as it is no fault on his own. That's the equitable thing to do. Read additional case law below for your studies, where both parents have demonstrated equal ability to effectively care for and nurture the child, as here. It is in the child's best interest that a custody award be fashioned which will best encourage continuing and roughly equal contact with both parents, given the practicalities involved. It's still a statute. They're still infringing on your private rights. This is why I don't understand how the fuck grown men and women cannot sit down and talk about this shit and make private contracts that are only adjudicated under the equity jurisdiction uh, of a superior court. I'm gonna say a superior court, not an inferior court. I don't understand that shit, but it seems that that's just how some people are. I don't like it. Just to let y'all know, I don't like that shit. But this is what happens when you take your ass to court. You don't know what the fuck you're doing, and you hire an attorney because you think you're doing the right thing. I get it, y'all. I get it. I get it. I don't like it though. Joint physical custody, OCGA Section 1996, Section 3, should not be automatically rejected simply because the parents live in places distant from each other. Okay, and there's the case law right there. Looks like a Georgia case. Okay. However, even with this ruling above, there is no mandatory requirement that a court do so, as a judge's ruling will be upheld whilst using the best interest standard under a judge's exercise of discretion. However, invoking fundamental protections provides substantial protections as applied to the father. I'm gonna stop right here, y'all, and I'm gonna talk about this discretion shit. I'm gonna prove to y'all that they don't really have discretion. Um, when cases go to the Supreme Court of each state or whatever, and a decision is made, who can you appeal to? if you don't like their ruling and argue in abuse of discretion? No motherfucking body, unless it's the sovereign people. But they have to wake up and realize that they're sovereign and that they have the final say so on what the law is. But I'm not talking about that right now. So let's just cancel that out of our minds. Who do you appeal to? Who? You don't appeal to nobody. That's my conclusion on why these so-called lower courts do not have discretion. I don't think that they have discretion because they're administrative agencies. And you don't have discretion in administrative agencies. You do what the fuck the statute tells you to do. That's just my take on it. And these are all administrative courts. These are all inferior courts, aka legislative courts. I'm reading y'all the statutes. These are administrators. They're performing ministerial duties. That's what the fuck they doing. And if you can't understand what I'm saying, let me see if I got it. Well, I'll do it later. But I did a video on it. Y'all should go and watch that video. The name of the video is called "They Are Not Courts, They Are Administrative Agencies." It's on my YouTube channel. The non-custodial parent is given only the right of visitation. Joint legal custody does not require proximity. And where practicable, it enables both parties' involvement in making major decisions concerning the child. I don't give a fuck. You're still infringing on their private rights, even though they don't know it, because you're ordering them to do something. But damn, what it say? When you're infringing on private rights, that is what they're doing. Attorney says parental power in the proceeds of his child's services and labor is not lost because he is still entitled to his child's services and labor as a non-custodial parent. However, as stated above, the loss of custody deprives the father of the right to services, therefore relieving him of the duty of support. Until majority, a father is entitled to the services of his child and the proceeds of his labor, and that is parental power, and that this parental power is lost, one, by voluntary contract, releasing the right to a third person; two, by consenting to the adoption of the child by a third person; three, by the failure of the father to provide necessaries for his child or his abandonment. 1904 Georgia. The right to the services of the children and the obligation to maintain them go together. Whatever deprives the parent of the right in the custody and services of the child without fault on his part relieves him from the duty to support the child. Another Georgia case. Let's see how far along are we. Okay, got about 30 more minutes. Okay, so in essence, fathers have a property right at custody proceedings to invoke for the purposes of displacing the best interest standard with heightened scrutiny protection than it otherwise sits only for the purposes of protecting. Joint physical custody for the fathers, which custody is already in the mother, because absent such joint physical custody, fathers essentially lose parental power by being identified as non-custodial parents. Read this again. Joint physical custody for fathers, which custody is already in the matter, or which custody is already in the mother, because absent such joint physical custody, fathers essentially lose parental power being identified as a non-custodial parent. Okay, I see what they're saying now. I see what they're saying. I can see why they're saying that. Absent joint physical custody in a court order, fathers lose parental power by being identified as non-custodial parents. Why? Because the non-custodial parent is given only the right of visitation. I see exactly why they say that visitation rights are not custody. Damn sure ain't. Non-custodial parents lose property rights to services and labor of their child in custody hearings where there is an adjudication of their rights, meaning their parental power. However, it is all done without a finding of whether his loss of parental power was any fault of his own. I agree with that. I haven't read any cases really like that for real. There has been no loss of parental control by the father, but there has been an award of temporary custody to the mother pending divorce proceedings. We do not believe that under the laws of this state, an award of temporary custody to the mother pending divorce proceedings would be such a decree of the court as would serve as the basis for conviction of the father of kidnapping his own child from the mother. A decree awarding temporary custody is a matter of discretion with the court. It is not an adjudication of the rights of the parties. The best interests of the child pending adjudication of the rights of the mother and father are the basis of the award. The parental rights of the parties are not adjudicated by the award of temporary custody. Let's go down. I'm going to get me some water, y'all, and I'll be right back. All right, y'all. Sorry about that. One could argue that even a temporary award of custody diminishes the rights of the parties, and an award of temporary custody is simply another name for final order. Even if there is no adjudication on the rights of the parties, the things that fathers ought to do, raise their children and receive their services, are affected pending a final order. Excuse me. If I was the father and a court attempted to make a temporary order under the circumstances, I would appeal this decision quickly and motion to stay those proceedings pending appeal because fundamental interests are affected. That's a good argument. This essentially forces the higher court into a catch-22. If they do not run from the question, nonetheless, if any rights are affected, then I would rule in favor of any argument mentioning this claim and overturn this case or respectfully dissent. Let's see what they're talking about. Important. We should certainly go over the without fault on his part, as read in the case law. The right to the services of the children and the obligation to maintain them together, whatever deprives the parent of the right to the custody and services of the child without fault on his part, relieves him from the duty to support the child. If a court were to allege that fathers have been deprived of the right to the child's labor and service, his property right, due to the sole fault on his part, then how and when did his fault occur, and when was it adjudicated? I have explained this thoroughly above. I would only find fault based on misconduct of an alleged married man who broke his vows and abandoned his child, but not otherwise. An unmarried man who made no vows therefore owed the mother nothing more than to be a non-absent father to their child, which is essentially not owed to her but the child. I agree with that. The father is primarily entitled to the custody of his children, but if his conduct has been such as not to entitle him to their custody and to cause their custody to be awarded to some other person in divorce proceedings, this award of the custody to another by reason of misconduct on part of the father of itself does not relieve him from his legal obligation to support his children. That's the same case he has cited above. Moreover, I would only find fault if the father did not abandon his child while turning down custody or refusing to provide basic maintenance while the child was in his custody. But what about a woman who breaks her vows? Fault on her part? More arguments father are not making. It should be important to mention that the failure to provide maintenance I would call separate and distinct from child support. In other words, there are moral and legal duties, maintenance being moral, the other being legal. Important notes for Georgians, former 1933 code is construed with the 2020 code decisions together involving custody cases, which means that these old cases apply or is construed with the current statute. For any outdated for any outdated law claims, Section 1991 and 1993 construed together in child custody decisions. Courts have construed former code 1933, Section 3127 and 74107. Okay, so they've construed all this together in decisions and involving child custody and divorce actions. Notice that they keep talking about these statutes, y'all. These are all fucking statutes. That's because these are all administrative courts. They're legislative courts. You have no fucking business in a legislative court. You don't. That is for fictions. That is for citizens with a lowercase c. That's what those courts are for. That is for the subjects of the legislature. You have zero business in an inferior court. Inferior courts are legislative courts. That's what they are. And you have zero business in them. None. All right, let's go to part two. Just to let y'all know, like if y'all don't like the way my voice sounds or whatever while I'm reading this, y'all can simply just pause it and then read what you want to read and then just unpause it, do it like that. Okay, part two. So how do fathers avoid visitation and receive joint or full custody in initial custody proceedings that determine custody and avoid child support? How do we reverse any of these decisions that have already occurred? I'm gonna provide some commentary on something right now. Stuff like this, when it comes to kids and stuff like that, any type of property, anything that is serious to you, this shit needs to be on paper. That'll solve all of that. That'll solve all of those problems. It needs to be on paper. Y'all need to sit y'all ass down and talk about this shit. And when you talk about it, you need to convert what you're saying into an expressed contract. And don't be greedy. Don't try to make it a one-sided adhesion contract. You need to be fair and you need to be reasonable with what you're asking for in this contract. That would avoid all of this shit. So if let's say the mother, she's fed up or something like that. You know how generally speaking, women they're extremely emotional, which is that's dangerous, by the way. Being emotional is okay. Everybody's emotional, but when you're too emotional, that shit is fucking dangerous. You're a danger to yourself when you're too emotional. But anyway, let's say that she runs her ass down to one of these legislative courts and files for custody or something like that or something. But before her doing all of that, there's a contract that you and her made. And in the contract, it is required of her to you and her are required to go into some type of negotiations before she results into that some form of mediation to resolve this issue in regards to your kid, conditioned upon if you are at fault with why she wants to go to court or with why she's having an issue with whatever. Do y'all see what I'm saying? It needs to be something like that. That's what you need to do. So let's say, if she did run down there and do that, but she didn't, abide by the rules within the contract, would abide by the law within the contract, because they say contracts makes the law. So then you can file a motion to dismiss because you have a private contract with her and that she's required to do certain things before she can come down here and invoke her rights under this contract in a court of equity. Do y'all see what I'm saying? That's shit like that needs to be done. That's why every time when you go and do business with any type of corporation, there is either going to be an express contract or an implied contract. That's it. And majority of the times, it seems to be an express contract. That's what y'all need to do, man. Okay. By utilizing the property rights and custody hearings to protect your pecuniary interests in support proceedings and ignore the dissents of those who secretly have an interest to keep you exactly where you are, lost, afraid, confused, and utilized as a secondary welfare system created by the state to receive Title 4A funding. I'm not sure if that was Title A or D that he meant. I mean, I'm not sure if he meant A or D or whatever funding. Review the three-part series below to determine how you should proceed in any matter. Okay, let's see what he's talking about. Let's see what she talking about. Three-part explanation series 1, 2, and 3 for circumstances involving custody and support. A father who has not legitimated a child but petitions for custody, or mother petitions for contested custody. Okay, a father who receives an application for services or any form of uh, document from Title VD or from Title 4D, and there is no child support order. Okay, a father who has been adjudicated the father and has a court order for visitation, supervised visitation, or joint custody, not to be confused with legal custody, meaning the right to make decisions on behalf of on the child's behalf, who has been ordered to pay child support. Series 1. Fathers who have not received custody but wishes to petition for custody or have been served with a custody action that is not contested are always in a superior position to assert his rights at the outset of the initial hearing determining custody and eventual child support. I can agree with that. This is the right to the services and labor of his child. You must remember that whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. So the so-called courts are going to be very careful about that. They're going to be very careful about that. So let's see. There seems to they put in a lot of they put in a lot of work doing this. A court order of visitation is not custody. So let's see, joint custody. Well, you know what? I'm not going to read this and go over this right here. If you have a copy of the book, then yeah, you can do it. What I'm gonna do is I'm gonna sit this here for probably about 30 seconds, just so y'all can see it, and you can pause the video, and then you can just read it and go over it. I'm gonna start reading down here in probably about 30 seconds. Let's see. All right, I'll give it about 30 seconds. Okay, all right. Now I'm gonna scroll on down, and we'll start off back right here. Repeat after me. A father cannot and could not have been forced or compelled by the state or a parent, mother, to pay child support if he does not or did not have custody of his child, so long as his parental power, right to the services and labor of his child, has or was not lost due to fault on his part. Okay. which fault is always, in most cases, the failure to provide private maintenance to his child while the child was in his care. I see. Read the below case law with clarity. The right to the services of children and the obligation to maintain them together go together. Whatever deprives the parent of the right to the custody and services of the child without fault on his part relieves him from the duty to support the child. There can be no doubt but that the awarding of the custody of the child to the plaintiff mother in the decree of divorce deprived the defendant father of his right to her services. He could not command her services while the plaintiff was entitled to her custody. Indiana Supreme Court case. Looks like the oldest one is from 1879. So they've been new about this. Let's see. The Supreme Court of Indiana has provided the basis and precedents to lawfully articulate in any state. I would agree with that because that is an equitable principle. How are they going to take your kid away from you without any fault on your part and order you to pay child support? They infringed on your private right without any lawful purpose to do so, and they're ordering you to pay child support. Another infringement on your private right without any lawful purpose to do so. The Supreme Court of Indiana has provided the basis and precedents to lawfully articulate in any state that not only is the father deprived of his child's services if he cannot command his child's services due to the child being in the care of the mother, but that he is not entitled to pay her private maintenance if the child is not in his custody. These case laws have been totally hidden because the amount of money that the states would lose if fathers substantially participated in joint custodial arrangements. Once a father overstands these case laws, then a father can easily maneuver in custody proceedings to ensure that not only does a court infringe on custodial rights because property rights are at stake, but that doing so would deprive the court of any chance to order child support absent fault on the father's part. Reading the chart above, you now have a visual of how joint custody should not only be protected but asserted in custody proceedings, in custody hearings to protect against every other weekend visitation and increase the standard for how false allegations and evidence, what was that? And evidence is to be considered in strategic legal complex cases involving lawyers whose sole purpose is to prolong litigation to increase attorney fees. Your goal is to quickly end these hearings while ensuring that a court cannot determine through any use of evidence in custody proceedings that parental power has been lost or relinquished by you or that you are an unfit parent. Once fitness is proven and parental power is not lost, joint custody is a given. You now know that parental power can only be lost by one, voluntary contract, releasing the right to a third person, two, by consenting to the adoption of the child by a third person, three, by the failure of the father to provide necessaries for his child, or his abandonment. There must be some more. Yeah, there's got to be some more of it to it because there are see these little lines right here, these little dots. When they do that, that means that that means that they didn't cite the entire holding right there. That's normally what that means. Read this Georgia statute, OCGA. I think I already read this. I'm gonna read it again. Until a child reaches the age of 18, which is the age of majority, or becomes emancipated, the child shall remain under the control of his or her parents who are entitled to the child's services and the proceeds of the child's labor. In the event that a court has awarded custody of the child to one parent, only the parent who has custody of the child is entitled to the child's services and the proceeds of the child's labor. Most cases, if not all current readers, have cases involving women who have removed or secreted their child from the father, and now the father has, or in the past, had no choice but to petition the court in order to see his child more sufficiently and without burden of the mother. In such situations, this father will petition the court for joint or sole physical custody. This can be done by a simple court form. The real legwork comes after. A sample parenting plan is provided on page. Okay. These parenting plans, in most cases, must be attached to the petition as an exhibit. Amend as needed. Okay. Do I need to read that again? Yeah. I'm not going to read that again because y'all already know what it says. Y'all can read it again if y'all want to. I think the numerous repetitions repetitions of placing these holdings in the court case are necessary to get this shit drilled in your mind. So I think the author did a pretty good job because it's already drilled in my mind now. You know now that if a father is deprived of parental power without fault on his part in the custody proceeding, then according to the body of case law, that must be given full faith and credit in the other states. Okay, a grant. Okay, I think I see where they're going with this. A grant of visitation will infringe upon a property right without clear and convincing evidence arising under strict scrutiny protection and or so-called without substantial justification. Be mindful of other strategic remedies such as declaratory relief, shown soon. To ensure the court is aware of your property rights, then utilize the template found on page. So I'm guessing there's one down below. In conjunction with your request for declaratory relief to ensure the rights of the parties. Meanwhile, you're not you now know your whole entire strategy is to destroy all claims brought against you to prove that you neither abandoned your child, failed to provide your child maintenance while the child was in your care, because in most states the mother refused to give you custody. Whatever deprives the father of the custody relieves him from the obligation of support. So this I think what the author is saying, I'm gonna highlight this. So let's say if the mother temporarily deprives you of the custody of your child for, well, let's say a year, 2 years, 3 years, 6 months, or whatever. During that duration, because it was through no fault of your own, you were relieved from the obligation to support the child because she deprived you of the custody of your child. How are you going to take care of a child that's not in your custody? They're going to want you to pay child. That's where they always come in with child support. uh, just giving the mother money or whatever. Now I do understand that. Yeah, it seems like the right thing to do would just be to send her money, to take care of the child. But you are not responsible for that. She's keeping the child away from you. That's what she's doing. So how is it fair for her to keep the child away from you and demand you pay her private maintenance in regards to the child? That is not the equitable thing to do. I get it. I like this right here has opened up a whole lot of I'm gonna say conclusions. I'm gonna say reasonable conclusions based on reading this stuff. Let's see. Where was I? I'm gonna start back. I'm gonna start back right here. Meanwhile, you now know your whole entire strategy is to destroy all claims brought against you to prove that you neither abandoned your child, failed to provide your child maintenance while the child was in your care, because in most cases the mother refused to give you custody. Whatever deprives the father of the custody relieves him from the obligation of support. Is that clicking for y'all? So they can't say you weren't supporting. Like let's say if they say that, I'm gonna start back right here after that. But let's say that they argue, they want to try to argue that you haven't provided child support for this child in 5 or 6 years, and you say, you know, I don't know where she is. I don't know where she is. I can't take care. I don't know where she is. So how is that fair or just for her to demand that I pay support, which I don't mind doing? You know, I don't mind taking care of my child. But how is that fair for her to demand that I just give her money and she keeps my kid away from me and does whatever the hell she want to do? What they'll do is they'll try to adjudicate you the father or something like that if you're not already adjudicated the father. Then order you to pay child support, and once they order you to pay child support, then they'll order her to give you visitation, or some sort of type of cut. Fuck all that shit. That's just my take on it. I don't have time for all that shit. I'm not finna go down here and pay this administrative fee, then hire a so-called attorney if I don't know what the hell I'm doing to litigate this case for me. They're probably not gonna do a good job. Not only that, this shit is gonna cost you like I'm not going through all that shit just to see my son. I shouldn't have. The only reason why I'm not gonna go through that is because I should not have to go through that, and also because I don't want these motherfucker folks, people in my business, telling me what the fuck to do, and I value my privacy. I'm not going through all that. That's just me personally speaking. Some of y'all may disagree, my nigga. I'm not going through all that shit. Fuck them folks. But y'all know how women are. Generally speaking, they don't stay mad forever. They stay mad for, well, let me rephrase that. Some of them motherfuckers can stay mad for fucking ever. So, but anyway, sometimes, they'll calm down, they'll cool down, and then they'll start back calling again and start letting you see the kid again and so on and so forth like that. Just little stupid shit like that. Anyway, sorry about that, y'all, but that's just, like, I've been going through some personal shit very similar to that on my own. And like, my man, look, I'm not. No, we're not going. She could take her ass down now to the courthouse and go through all that shit she want to. I'm not going to. I'm not participating in none of that shit. All that shit is voluntary anyway. I'm not going to a legislative court and looking for them to protect my private rights. They don't give a fuck about. I'm not going through that shit. Anyway, or did any other act deserving of losing parental power, such as sexual abuse, extreme neglect, or voluntary relinquishing the right to a third party. Let's see. You can now do this by and through your own discovery methods, which are requests for admissions, that's right, depositions, requests for interrogatories, and your own use of affidavits and witnesses. They are right when they say that. Request for admissions, are you saying you're requesting for them to admit or deny something? A deposition is where you would go to either an attorney's office, or you would do it outside the court or anywhere. There'll be a court reporter there, probably a camera, a microphone, and they'll get you to hold your hand up. Do you swear to tell the truth, the whole truth, nothing but the truth, blah 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 stuff. And then the attorney there, they will ask you questions and so on and so forth. It's like you're testifying out of court under oath. It's the same thing as an affidavit, basically, but it's just like it's more of a interrogation. It's more interrogational as opposed to affidavits or whatever. Requests for interrogatories. I've never heard of requests for interrogatories, but they're actually called just interrogatories. But anyway, interrogatories are written questions that you send to the other party that they are required to answer under oath within 30 days. And y'all know what affidavits are, and y'all know what witnesses are. A consultation with an attorney or limited attorney for certain purposes could be of assistance to you. In case of mother desertion, all you need to show in custody proceedings is that the mother kept the child away from you for no good reason and refused to allow you to see your child and that joint custody should be granted because one, you are a fit parent, and two, you cannot be deprived of property rights in your child right to the services and labor of your child, absent fault on your part. That's on point. Like that shit is short and simple and straight to the motherfucking point. That's a good argument. And once you make that claim, they got to come back and rebut it. That's a good argument. Short and straight to the point. That shit ain't number like 2 or 3 lines. In addition, in cases of mother desertion, all a father needs to show is subsequent child support proceedings, usually ruled upon after custody is determined, that again, there is no fault on your part, only the fault of the mother. No state can force or compel a father to pay in such cases. That's pretty good. When a man abandons his child and casts it upon the public, he becomes liable for its support. But it is entirely impossible to treat a child as thus cast upon the public when the fact is simply that the mother has deserted the father and carried away the child and continues to support it. Let's see where we at. And I already went over. I'm gonna read. What number is this? I'm gonna stop on page 26. I'm gonna go up and read this, and then that'll be it, y'all. The case law simply proves that the state would have no articulated governmental interest, meaning a compelling public interest, as applied to you because you have not cast your child upon the public. And therefore, the state and neither your child's mother can force you to pay anything by ordering child support monthly payments. A state's interest in forcing fathers to pay child support comes solely from the fact that fathers fail to provide for their children. They damn sure do. That's 100% true, man. That is true right there. Overall, as applied to you, however, no fault on your part. That's right. That motherfucker did some research on this shit here. They did some research when they put this book together here. As such, neither can a child support agency enjoin itself nor force any support obligations upon you as the father because the state will lack the articulated interest it needs as applied to you because, again, it is entirely impossible to treat a child as thus cast upon the public when the fact simply is that the mother has deserted the father and carried away the child and continues to support it. They damn sure right. If this series applies to you and you come into receipt of a letter from Title 4D Child Support Agency, see page for your responsive document, which will most likely result in a refusal by such agency to enforce such a case. If this series applies to you, see series 1 above, then you must keep a detailed record of every date the mother refuses to allow you to see your child. If the mother wishes to condition your physical custody, seeing your child, on a purported child support payment, then document every such occurrence. Also remembering that the custody and support go together and that whatever deprives a father of custody relieves the father from the obligation to provide maintenance. So back again to what I was saying. If the mother kept, let's say the mother, she stayed mad at your ass for you did something, y'all not together, but you did something, it pissed her off, and she mad at your ass for 90 days, 100 days, a year, let's say a year, and she kept the child away from you for a year. Then, as a matter of law, what the author is saying, then as a matter of law, you are not under any obligation to provide maintenance for that child. In other words, to support that child because she's keeping the child away from you. So what they're saying is, through no fault of your own, you are not taking care of your kid. Do y'all understand that? Does that make sense? That make better sense? That's exactly what the author is saying. That makes sense to me. Instead of them just trying to say, well, you should have been giving her support. Or they'll say, when you do give her support, they'll say that shit is a fucking gift or some shit like that. That's what they'll say. That's how you know that they have a pecuniary interest in this shit. If they didn't have a financial interest in this shit, I don't think that they would be going through I don't think that they would be putting all these people on child support, putting all these men, on child support. Not only that, if if these courts are not corporations and so on and so forth, why the fuck do they have insurance? Because they all have insurance. That's why the judges are bond. That's why these so-called judges have bonds. Crazy. Important bonus section must read. Although we know now that parental power can only be lost by consenting to the adoption of the child by a third person or by the failure of the father to provide necessaries for his child or his abandonment, according to the case of 1904, the parental power can also be lost by one, voluntary contract releasing the right to a third person. I'm going to stop right there because I'm already over the time limit, about 70 minutes right now. So I'm going to stop right there. And if I have time, every day that I have time throughout the week, we'll pick up and we'll just keep going back over this stuff, y'all. Hopefully this is helping y'all. Hopefully y'all are enjoying this information. Y'all need to go and read these cases. If you're doing your research and you can't find this case, okay, y'all let me know if y'all cannot find any of these cases. And I'm almost certain I can find it. They can't really hide too much. I know. I just know how to find shit. I'm just sorry. I just got a gift for this shit. It seems or whatever. But I'm pretty sure that I can find it. Is what I'm trying to say. So if y'all cannot find any of these cases the author is citing, let me know, and I'll do a video on it if I need to, or I'll just send you the case, or probably both. It doesn't matter. But anyway, I hope this information is helping y'all. To the fathers out there who really want to be in their kids' lives and are really trying, I'm rooting for you. Okay, I'm rooting for you. This information is for you, and that also goes along with the mothers too. To the good mothers out there, the good parents, generally speaking. This information is for you. I think I'm gonna do one more video today, and that'll probably be it. The Supreme Litigant is out. Peace.